Today we are going to look at the role of consideration in common law, contract law. The first question we have to ask is, what is a contract? A contract can be defined as an agreement that is binding or which may be enforced in law. Thus, if a party does not comply with their contractual obligations, they will be in breach of contract, and the other party can apply to the courts for a remedy. Now we have to look to see if there are any differences between common and civil law contract law. Although the contract law system in common and civil law countries is fundamentally based on the same economic principles and methodology, there are nonetheless significant differences between the two systems. As we know, common law contract law has been developed primarily by way of case law. Civil law contract law, in contrast, has been developed primarily by way of a system of codes. Under a codification system, rights are defined in advance and then applied to a certain extent irrespective of the specific facts of each particular case. On the contrary, in a system based on case law, rights are developed after a problem has occurred and apply specifically to the parties who have decided to bring the case. This fundamental difference has led the civil law to put in place a system where precaution becomes as important, if not more important, than opportunity. To the contrary, in the common law, as a result of its methodology, opportunity is naturally prioritized over precaution. Consequently, the notion of freedom of contract is much more developed in common law countries. Thus, for example, with the exception of public interest rules, most common law contract rules only apply if the contract between the parties is silent on the issue. Thus, the parties are free to effectively adapt the law to their specific needs, choosing whether or not to benefit from its provisions. In contrast, rights and duties created under civil law tend to apply irrespective of the terms of the contract entered into by the parties. Indeed, in the civil law, there is a tendency to classify society into categories, certain automatically deserving of protection and others automatically owing protection. These rights and duties will then apply irrespective of the contract that the parties may have entered into. The common law, where possible, avoids this categorization approach and instead, through the technique of case law, attempts to define rights based on the actual facts of each case. This fundamental difference can be found in the name given to the law governing contracts in common law and civil law jurisdictions. The common law simply refers to contract law. This reflects the fact that in many ways, contract law is a private form of law, and any duties imposed on the parties flow primarily from the actual contract they have entered into, and not from a public obligation. Thus, in a contract, one is constrained to perform, not because they should do something, i.e. the existence of a moral duty, but rather because they agreed that they would do something and receive payment. This payment is referred to as consideration. The civil law refers more to the nature of the parties' duties and what they should do. For example, in France, contract law is referred to as le droit des obligations. Clearly, the emphasis is immediately put on the parties' obligations or duties and what they should do, what they are obliged to do. The result is that the civil law does not necessarily require consideration, as one is duty-bound to perform not because they receive payment, but because they are morally bound to do so. In the common law contract model, the primary role of contract law is to identify whether there is a contract between the parties. As to what the parties should do, well, common law leaves the parties free to decide that in their contract. It is only if the contract is silent that the courts will ask themselves this question. So what is the role of consideration? Thus we can see the importance of consideration in the common law contract world. If contracts are not about what people should do, i.e. if people do not automatically have duties vis-à-vis others, then in order to have a right over another party, it is normal that the common law system require a party to confer a benefit on that party. Thus, it is primarily the parties through their behaviour and not the state that define the extent of the rights and duties that exist between them in contract law. It is from this philosophy that the benefit-detriment theory was developed. There are a number of basic common law rules applicable to the area of consideration. For example, performance of a pre-existing duty is not good consideration. By this is meant that if a party has already a duty to perform an obligation, he or she cannot use the performance of that duty as consideration to enforce another promise. In Stilk and Murrick, a sailor had been promised payment of £5 for working on a ship. Some of the crew deserted the ship, and the sailor was offered more money to stay on board. The court held that he had no right to receive the extra money, as he was already duty-bound to stay on board for the original amount of £5. Another rule is that past consideration is not good consideration. The consideration offered has to be contemporaneous with the promise of the other party. In Eastwood and Kenyon, a guardian took out a loan to educate a young girl in his care and to improve her marriage prospects. She later married, and her new husband promised the guardian to pay the loan, but never did. The guardian sued for payment, but the court considered that he had not given the husband any consideration for his promise, as the loan had been taken out and the girl educated prior to the promise by the new husband to pay it. Another rule is that consideration must move from the promisee. This means that in order to be able to sue on a promise, the party suing on the promise must have supplied the underlying consideration on which the contract is based. The final rule we'll look at today is that payment of a lesser sum is not considered good consideration for the discharge of the entire debt. In Folks and Beer, Folks owed Beer money, and Beer successfully brought a court action against him. After the judgment, Folks agreed to pay Beer the original sum by way of installments, and in return, Beer agreed not to require payment of the court-ordered interest. After Folks paid the debt, Beer, in breach of her promise, sought payment of the interest. Folks refused, as Beer had agreed not to enforce payment in return for his paying the debt by way of installments. However, the court considered that the agreement was not enforceable because the consideration offered by Folks in return for the promise not to charge interest only amounted to a partial payment of the money he owed Beer, and so was not good consideration for the entire debt. Unlike in the civil law, consideration is a cornerstone of the common law contract law system and is normally vital in order to have a legally binding contract. We hope you enjoyed this look at the role of consideration in the common law contract law system.